Fantastic. Thank you, Deborah. Well, welcome everyone. I'm Eric Giegerich. I'm the director of UC Berkeley's Industry Alliances Office, and today's presentation on how to read your data use agreement is a feature as part of the brown bag series of the Berkeley Research Data Portal. And as I've already said before we started recording, Terry Sale, also on this call, is going to present sharing your data with third parties on November 9th. So that's next in our series. We'd love to see you there for that one as well. So how to read your data use agreement. And this is for mainly for researchers, but it's really for everyone. So hopefully we've got enough here to meet all folks. So the scenario, let's just take a hypothetical. Our office, let me just say, our office handles data use agreements, research data use agreements. So if you have one, send it to us and I'll say something more about that. But here's a common scenario. A data provider agrees to give you their data. They send you their data use agreement, and you might be looking at it and saying, what do these terms mean? Can the university agree to this? And who reviews and signs this? So I just want to say that the Industry Alliances Office, that's my office, the Industry Alliances Office handles research data use agreements. And we have I can see if I can grab this. Well, I can't grab it while I'm talking. I was going to put the link to how to receive or send materials or data into the chat. Maybe somebody else could do that for me. So we have a way for you to let us know about your data use agreement or your need for something. Do contact us. There are a few places on the Berkeley campus, if you have a data agreement, a few places to have it looked at or reviewed, or a few places to go to talk about how to get data. So our office is one, the Industry Alliances Office, and we handle, again, incoming research data use agreements. You can go to procurement if you have a commercial data set and it's for a fee. That's a different group, procurement. Library already has licensed data sets in our library collection. You can go talk to them. And as I said before we started recording, the Berkeley Research Data Portal, here's the link. You can go there. It's hopefully a one-stop shop for resources and experts on the Berkeley campus, all things data. Again, if there is something that you're surprised isn't there or would like to see there, do let us know and we will talk about putting it there. Okay, so here is that page for the Industry Alliances Office. Receive or send materials or data. If you have a data use agreement from a provider, or if you want to talk about how to get data, research data, go to this page and we will reach out to you. So this presentation is about research data use agreements. And what we're going to cover is your research data use agreement, its structure, its terms, what that all means. We'll look at a simple data use agreement and we'll build up some general concepts. There are quite a variety of ways that it can look, and depending on a bunch of factors, which we'll cover in just a moment, there may be quite widely varying terms in your data use agreement. Our goal today is to empower you to navigate your data use agreement and manage your rights and duties. So just as a way to think about what does a data use agreement cover, the type of data that you are seeking or will be given or are promised can drive the data use agreement terms that show up in your agreement. So for example, and these are only a few examples, but if you have human subject data, whether it's health data or whether it's prison data or some kind of social service or state agency data, healthcare provider, medical, you're going to most likely, you will have a CPH protocol. And we'll need to know the protocol number, or you'll have to have a protocol number. We'll have to ask whether the data is personally identifiable or if it can be de-identified. The question is, does it include personal, medical, or health information? And is the data covered by HIPAA? So all of those things, sort of triage questions, will in some way determine what we expect to see in the data use agreement, or what it already covers, or what we may want to put in. Also, another category is export controlled technical data. So this wouldn't be about people. This would be about designs, software, different kinds of process design kits, and so on. So we would need to know the export control classification number, or the ECCN, and you may need a technology control plan, sometimes called a TCP. I could have put that there. So all this to say, there are other types of data as well, but sometimes what the data type is and what its status is can determine what kind of terms you'll see in your data use agreement. Then let's talk about types of data use agreements. Not that there are different types out there per se, but how it looks, what form it takes, what terms it has, is all going to depend on what type of data it is, what kind of provider it is. Is it a commercial entity? Is it a state entity? Is it a medical system? Is it other university data? The status of the data. Is it covered by HIPAA? Is it subject to US export controls, and so on? And it's also important to say that just because you have certain terms in the agreement doesn't mean that they are necessarily rock solid. Many terms are negotiable, and we might need to look on our campus at, can we address a security breach in 10 hours, or do we need 72? And so many terms are negotiable, and we need to make sure that the UC Berkeley campus can handle the terms we receive. We may want to put in some terms of our own. So data use agreements can look quite different. Okay, with that, let's just go through a simple data use agreement. And again, this is just an example. It's a little bit of an abstracted example. Your data use agreement may look quite different. Probably won't look different appearance-wise, but it could have a number of different terms. So a data use agreement will have a preamble, and that is, if you can see my cursor, that is this part right here. I don't know why. Oops, I don't know why looks like it's cut off. It's the beginning that says this agreement is effective on this date, and it states the parties. And a data use agreement will have a body with terms and conditions. So that's this part right here. Plus, I'm abstracting this a little bit, so I've cut out a lot just to give this overview. And then it will have a signature block. That's this part right here. The provider, their signature, their name, their title, and the UC Regents' signature, name, and title. And this is important to know. We strongly recommend that the Regents is the signer on the data use agreement, not you personally. That can be for a number of reasons. We can talk about that. But we strongly recommend that you send it to us or to another official office, and then we've sort of got your back in terms of reviewing the terms, making sure we can handle them, and so on. And then attachments. And so I have down here sort of a sample. Exhibit A, description of the data. There might be other attachments. You might, the other provider, or you might put on a sort of a research project. This is what we're going to do with the data. There might be security requirements. May not be. It may be something you can do in your department on your department servers, or it may require something more institutional, and we may need to vet what kind of security requirements are requested. I should say along the way, looks like we've stop me if you'd like, if you have a question. I won't be able to see, so maybe somebody else can watch questions, or else just unmute yourself and ask. So please do stop. I'm just going to run through, and then we'll have time for Q&A at the end, but if you want to stop me along the way to ask a question. So the preamble is, as I said, the beginning of the agreement. It states the effective date, and that's important because the effective date, this agreement begins on, the 18th of October 2023. That is part of what sets the term. If you have a one-year agreement, it's from October 18th, 2023 to October 17th, 2024. If you have a 5-year agreement, it's 5 years from the effective date, and so on. So that's important. How long do your obligation, how long is the term active? In other words, activities under the agreement can take place. Sometimes, as with non-disclosure agreements, there can be a survival period, probably not with the data use agreement, but it's important to know how long you have access to the data, particularly if you're completing some research. You want to make sure that you have the data for long enough. And then also, as I said, the parties, and we recommend that UC Berkeley or the UC Regents is the party, not your college or department or you personally. I'm grouping some terms, but then there are terms that are related to the data and data transfer or data access, depends on if the provider is actually giving us the data to store on our servers or if they are giving us access to a server that they manage. So that matters a lot, and the language will change a little bit according to whether they are transferring or whether they are giving access. Then there's a definition of data, and we try to define the data so we know if there's any dispute or if we need to ensure access, that we know what the data is, and that usually is an exhibit. It's something that's defined. It might be these data files, it's this description. And after we sign, if you and the data provider want to get more data or something changes, we usually would do that under an amendment, for example, if it, particularly if it really substantially changes. And then another attachment would be data security. I put that here because it relates to what the data is and how it is handled. So there might be a security plan, and that would be, if there's a separate security plan that is long, it would be thrown into an attachment. If it's short enough, it could be just a few terms in the body of the agreement. So then what is the data for? It's for research, and it's by a principal investigator and researchers in the investigator's lab. So we have a description of the research. You see in yellow, there's a spot to define, what it is. Sometimes the provider, usually they care what you're doing with the data. Especially, they might want to restrict what you research, what your research is, in some way. But there's usually a field of research. There might be a project title or project name, and then we will name a principal investigator, and then the persons in the principal investigator's lab or under their direction would have access to the data. So permitted uses and restrictions. This is an important part of a data use agreement. Providers don't often want to give a data use agreement for you to do just anything. They often put in restrictions. Permitted uses, you can use it for these things, and you can't use it for these things. And so usually it would be that you can use it for research and educational purposes, not for commercial purposes, or people under the principal investigator's direction can use it, but nobody else. Data might be confidential, often is. That's fine. That's why we define data, and data is different from your results. Data can remain confidential, but of course we don't keep our research results confidential. We're a research university and we publish our research. But confidentiality applies to their data usually. And then there might be provisions about, this again is in the category of restrictions, if it's human subject data, you don't go contact the human subjects, things like that. And again, there might be security requirements that are put into an exhibit. Okay, then there are things, so what do you do after you've done the research, or while you're doing the research? What do you get to do? You create results, you create publications, you white papers, posters, whatever. So we try to define those and we want to preserve. This is why it's very important why the university, one of the reasons the university wants to be the signatory, the reviewer and the signatory. We are here to protect your research, your right to publish, and how the results are used. And that often is in conversation with you. What are you trying to do? And we are your advocates. We are here for you to try to put into this agreement to enable what you are trying to do. Usually that's, of course, it's always publishing because we're a university. We're always trying to preserve the right to publish. And there may be other things that can be done with the research results. So we do want to define those. We define results separately from data, again, because different permissions attached to results than to data. Okay. Then there's not necessarily a section called this, but there are terms that relate to ownership, to license, to warranties. And I would distinguish between ownership, license, and warranties relating to the provider's data and relating to your results. So sometimes I will craft a paragraph like this with ownership, where we say the recipient, that's us or the university, acknowledges that the data with a capital D is the property of the provider, right? If the provider's giving us their data, we're not going to make an ownership claim to their data. They're giving it to us. It's theirs, no contest. And they retain a right to use it however they're going to use it. The provider of the data acknowledges that the results, that's your results, are the property of the recipient or of the university. And the university retains ownership of results. UC just came out with a policy recently clarifying ownership of research data. It's a UC system-wide policy, but that was already part of our policies. It just wasn't the clearest expression of it. Recipient retains the right to use the data however we will. Not the data, the results, however we will. We might give the provider certain rights in the results. That's to be determined. We also have a clause that says no grant, either way, that there's no grant of license or except for what is already described in this data use agreement. The provider is not granting us a license to do whatever we want with the data, and we are not granting the provider a license to do whatever they want with the results. These things are to be determined or defined in this agreement. And there's also usually there's almost always a no warranty clause, which means, the data is provided as is. We're not saying it's fit for any particular purpose, including a commercial purpose. The results also are provided as is. Again, we're not making any assertions that it's complete or perfect or industry grade or free of infringement or anything. It's just, here it is, as is.
I have a question.
Yes.
I was just wondering if you get that many data use agreements where our researchers are actually contributing additional data to that data set that they get. And then, so would we be the owners of that new data?
Yeah, that's where I think it's important to define results separately. So in the Industry Alliances office, this is again, we're looking at sort of a simple agreement, but very often there's sort of a two-way, right? Where the data agreement is covering some kind of collaboration. So if there's some collaboration, we want to distinguish what university researchers are doing with the provider's data. So the provider's data is as given. It doesn't include, we want to make sure that the definition of data with a capital D does not include what the university does, because we don't want the provider at the end of the day owning your work product or parts of your thesis, right? We want to make, I know, Terry, I think you were asking this question, so I don't mean you, but I mean you, the researcher. So we want to make sure to differentiate data and results. The results is what we do, including new data. Does that answer the question, or do you want to say more?
Sounds good, thanks.
Okay. So then there's a section for, did I skip something? Okay. For general legal terms. Many contracts have these, not just data use agreements. The term, how long is this agreement? I said already, it's based on the effective date in the preamble. Term can be 2 years, however many. And then there's usually a termination clause. And we like to have easy out for either party for any reason. Notices, so there are sort of researcher to researcher communications, and then there's also institution to institution communications. So you can contact whoever, you probably already have a relationship with somebody at the providing party. The notices is for the institution to institution communications, like legal to legal or business unit manager to whoever. Governing law, we want state of California governing law. We are in the state of California. We're a public institution. If there, I'm telling you this because this may affect your data use agreement. If it's another state like state of Delaware or state of New York or state of Mississippi, or another country like Kenya, the challenge with governing law and venue in that state is university, if there's ever a dispute, a legal dispute, university counsel lawyers don't necessarily probably don't have experience with that state law or that country law, and would need to retain outside counsel. So that's an extra expense. Who pays that expense? Your lab would be expected to cover that expense. So that's why we want to keep it to California law. Also, if UC attorneys, if UC Berkeley or UC attorneys had to fly to Delaware or New York or Kenya to litigate something, hopefully that would never happen, but somebody's got to pick up that tab, and the university doesn't have an extra set of funds set aside for that. So we try very hard to keep this to state of California laws and venue. That's part of why we want to be able to review your data use agreements and support you in negotiating a good contract. Okay, these are just general legal terms. Again, signature block. So we want the regents to be the party. It's not a personal agreement. It's not an agreement with the college or department. We certainly, if the college or department is playing an important role, there's a difference between having a legal role and having a sort of PR or optics role. We're very happy to put into the preamble, for example, that it's, or even to put in a title way up on top, something that highlights or foregrounds your department, your center, your institute. If those kinds of PR optics are important, we'll put it in, not a problem. It's not a legal matter, it's an optical matter. But legally, the party is the regents of the University of California. And again, this is all to safeguard you, your team, your lab, the university, the data, your research, and your publication. Sorry, it's taking a moment here to, there we go. Sorry, there's a delay here for some reason. Okay, and then appendices. So I've already mentioned this at the beginning. There can be a description of the data. That's this little graphic up here. I've got graphics for all these. The research and security requirements. Typical, there may be other appendices, but this again is sort of and there may be no appendices. But this is just an example as a mock-up. And then once you're good, we're good. We've communicated, everything is to your satisfaction, is to our satisfaction. We sign, you get the data, and you're off and running to do your research. So that's how to read your data use agreements in a nutshell. And with that, I can take questions or we can have discussion. Does anyone have
I had a quick question, just mostly so everyone can hear. So you're part of the Industry Alliances office. So do you do data use agreements for all parties or just for-profit companies?
Thank you. That's a good clarification. So the Industry Alliances office handles data use agreement, research data use agreements for all parties, for the entire campus. So it doesn't matter if we're the ones that handle research data use agreements. When it comes to other types of agreements, industry-sponsored research, we handle industry-sponsored research agreements. Sponsored Projects Office handles other sponsored research agreements. But for data, our office handles all research data use agreements with a federal provider, state provider, nonprofit company, anything.
Incoming.
Incoming, yes, incoming. If it's outgoing, if you have a question about, somebody has requested the use of my data, Terry, who is asking the question, is the person to talk to, or her office, the Office of Technology Licensing. Do you want to give a little preview of that, Terry?
Yeah, so our Office of Technology Licensing is that same website that was that Eric listed before, that you go to. Is like, it's incoming and outgoing, sending and receiving data and materials. So my office, the Office of Technology Licensing, handles all the outgoing materials and data. And I'll be talking about that in 3 weeks.
Yeah, November 9th. It's next on the agenda. So if you'd like, oh yeah, and thank you, Deborah, just put in the link to how to send or receive materials or data. So that website, let me just go there a moment. Let me share screen again. And oops, that's not, let me not share screen. Let me get the right screen. How did I get there? I wanted to show you something about how that works.
Can you click the link in the chat?
I know. I've got too many things open here. Where is that link? Sorry. Ah, there it is. Send or receive. Okay, now I'm going to go back to share screen. So IPRA, this is my office and Terry's office, IPRA, Intellectual Property and Industry Research Alliances. There's an incoming office and an outgoing office. Our office handles incoming material transfer agreements or data use agreements. So you got these two buttons here. Receiving is incoming. Those go to our office, and the outgoing, if you have something you want to send to, or you've had a request, they'd like buy materials, they'd like to have a copy of our data file, that go there, and Terry or someone in her office will receive that request. So thank you, Deborah, for putting that link in. Anybody else have questions about data use agreements, or what happens if, or what about this? Yeah, Chris. Hey, Chris.
Hey, Eric, thanks. Hey, I know we'll be talking about this in one of the later brown bags as well, but I was wondering if you could talk a little bit about kind of unpacking results, right? As we've had to do in some of our agreements where there's also maybe software involved, there might be like machine learning models or algorithms.
Yeah, really good point. And I'm actually working on something just like that right now that's quite complex. So this is part of what our office would do if you send us something and we have a sort of an initial call. I would be, or somebody else from my office would be asking you, what are you planning to do with the results, or what kind of results do you expect? Is it going to be just a data set based on analyses you're running on their data? Are you going to be creating algorithms? Are you going to be doing creating some machine learning? Is there anything potentially patentable? Is this in relation to any other contract or grant or any other obligations you have to another party, and so on? So we would ask all of these kinds of questions to try to parse what would be in the total set of your results. And again, this was a simple mock-up of a data use agreement. That more complex data use agreements might have a first right to negotiate for a license, especially if there's something patentable, or to other assets that might be coming out that may not be data, but that would have significant commercial value. So that there may be, we can talk about that. There's all kinds of different ways that can be done. In those cases, especially in complex cases involving intellectual property rights, one of the reasons why my office is joined with Terry's office is that we confer and talk about those tricky cases and how to apportion rights in a fair way that leaves something on the table for the university and provides something for either the data provider, if they have an interest in taking up, if they can take up and commercialize something, for example, or for other parties. We also, let me just say, as a research university, we always retain rights to use for research and educational purposes. So even if there might be something commercializable there, like there's a really cool algorithm and this could be a blockbuster invention, or this could go to a startup or something like that, still we retain the right to share results with other research universities, other labs, independent research institutes, and so on. Chris, does that cover it? Terry, anything you want to add?
No, I mean, it's the same things. We're looking at if it's a nonprofit institution that is requesting certain things, it's a little bit of a different story than a for-profit. There's tax consequences with giving, certain rights to a for-profit industry for free, these kinds of things. So there's all these considerations that have to go into what kind of license that we can give. But like Eric said, no matter what, even in our exclusive licenses, we would always retain for ourselves and other nonprofits the right to continue the research, to be able to publish on the inventions and things like that.
I'm just looking at the question in the chat, and if I haven't been looking at the chat because I've been kind of toggling to different screens. Either receiving or sharing data, how long can the whole process take? And are there financial costs associated with DUA preparation? No financial costs associated with it. We are a campus office. We are here for you, both my office and Terry's office, the Office of Technology Licensing. So if you are receiving data or giving data, we're a central campus office. How long can it take? Let's lift up the hood and see what's underneath. And it kind of depends on the complexity. It also depends on the other party. It depends on if we're using a standard template or if it's a really complex agreement. Or we might have gotten a very simple agreement for a very complex situation. And part of our discussion with you might be, what's going on? What are you contemplating doing? This is a very simple agreement and it may not cover everything that you're intending to do. So we may need to build up a few terms to protect what you're doing or to enable what you're doing. So I would say, typical lawyer thing, it depends, but it really does. And I think I've said this early in one of my early slides, depends on the data, depends on the provider, it depends on the status of the data, or classification of the data. So a lot of things all depend, but it shouldn't take too long, a few days or a few weeks to turn around a data use agreement, unless there's something very complicated, and then it could be a lot of back and forth. And it's not just our office, it's also how responsive is the other party.
I would add, it's also how much information we get from our researchers.
Yeah.
So sometimes it's piecemeal, and then I get in the middle of you're ready to do an agreement, and then you find out something completely different's going on. So yeah, that's kind of sometimes a big problem is that front end, getting all the information that you need. Yeah.
We are here for you. We're in your corner. So the more you share with us, even if I'll give you an example. A researcher recently reached out to me and said he's getting data from a company that he co-founded. So part of his question to me was, well, there's a conflict of interest here. How do I think there's a perceived, potential conflict. How do I manage that? What do I do with that? I'm kind of a little nervous about exposing that to the university. So first of all, I'm glad that he felt safe to share that, right? Because we are here for you. Let's walk this together, right? So I introduced him if he was interested, if he was willing, I introduced him to our conflict of interest coordinator. But I said, I talked to them a little bit about how our conflict of interest coordinator, or how our conflict of interest committee tends to manage conflict. And I gave him some assurances based on experience and said, I think the best thing is to have a consult and just explain the situation and hear from them what they would do in this situation. And so that all worked out very well. It was a good conversation. So that's just one example of share more. And then we can, the more you share with us, the more we can help navigate things for you in a way that keeps you in guardrails, in the university's guardrails, and also protects your research and what you want to do with the results. Let me see, somebody put a new comment in. Somebody said this in my name. How did that happen? Some incoming DUAs are also also include specific security requirements or security review, which can involve additional campus offices. Yes, thank you. That also has the potential to add complexity and time. Yes. So in terms of timing, there may be a number of reasons why we would need to go to other campus offices, and sometimes that back and forth can take time. Ideally, we will be sharing with you that process, like, there's some export controlled technical data here. I will need to talk with the export control officer. Do you want to get on the phone together or get on a Zoom call together? Or we'll need to have a data management plan, and there's a data security attachment. We'll need to talk with research IT, some folks on the call here. Thanks for joining. Would you like to get on a call together and talk about this? So hopefully we'll share with you what those things are and invite your participation. And then you can get a sense of, okay, I can see why this might be taking a little bit longer than I expected, because there's an additional piece, but I'm part of the process, and that helps me understand timing. Am I missing anything in the chat? Anybody else have questions about your research or what happens when? All right. Rick.
Well, I was giving time for people to raise their hand, but I'll say a little bit more about the data classification and the time it might take. I'm with Research IT, so Erica and others will send a data use agreement to us with the question, can we meet these security requirements? And so the first step we have to do is to figure out the data classification. And sometimes that takes a long time. We're trying to figure out how to do that quicker. It often involves bringing in the privacy officer, Scott Seaborn, and we've, in the last few months, begun to just do that more regularly, instead of us trying to wade through some of the legal things. So we're trying to make that process quicker. Things particularly that drive that, or if it's covered perhaps by a European or some other country's data protection regulation, like Eric said, certain types of information then would raise the classification from moderate to high. And with that higher classification, there needs to be more strict security in place. So first thing is to figure out the classification. Then we can figure out what systems you're going to use to store and analyze the data. So those are some of the things that begin to slow it down. Sometimes it's a contract with a vendor that's using software that is not under contract with UC Berkeley, and that brings procurement in potentially, or a vendor security assessment. This happens a lot with people using Survey CTO, or a group that seems to do field work, kind of the enumerating of surveys. And so there's that kind of thing where all of a sudden it gets beyond just the data use agreement. And that'll, we're trying to figure out how to make those decision-making go quicker, kind of cut to the chase.
Yeah, thank you, Rick. That's important color to help understand complexity. As many of us know, the volume of data available and the volume of data that many of you are creating every day, and the complexity of data and all the different emerging legal regimes that cover data, including privacy. I didn't mention privacy. I just wrote down that I should add that to my presentation. So thank you for mentioning that. And our campus privacy officer, Scott Seaborn, has also given a presentation in this brown bag data series, and we'll have him back again. So stay tuned. But the complexity has certainly grown. And that's part of why we have the Berkeley Research Data Portal. That's why we came together a number of years ago, back beginning in 2016, to begin to map out some of that complexity, and for your benefit, to reduce the hurdles to getting things done. So thank you, Rick, for highlighting those things, and thank you also to your office for efforts made to simplify things for the benefit of our researchers. Chris.
Yeah, thanks, Eric. I'm just kind of wondering about on the also on this kind of coordination side, when often the data that are coming in are related to people, and so they might be human subjects. So I just can't recall if like, are you, I mean, I know that that's a different office, but do you coordinate with them? Do you ask researchers if they've contacted human subjects?
Good call. Thank you. And I see that Adrian Tanner from the Office for the Protection of Human Subjects is on the call. So Adrian, feel free to speak up if you'd like. Yeah, what we do is ask if there is something human related in the data or in collection in the scope of work. We ask, have you been in contact with the Office for the Protection of Human Subjects? Do you have a protocol? And then we'll make an intro if needed. But yeah, that's a very important piece. If there's other research that involves human subjects, there's a human subjects protection protocol involved usually. And so one thing, so thank you for all the different people who are on the call from different offices. That we have a network here at Berkeley. We pass things back and forth, and that's part of our diligence. It's part of what we're doing on your behalf to make sure that this thing is caught or that thing is caught. We want to make sure this is part of our support for researchers across the board. And that's again part of why we've created the Berkeley Research Data Portal. It's not just a portal, there's also a network that's put all these things together, and we talk, we meet regularly and have conversations. Was somebody going to say something?
I was just going to add, Eric, that sums it up well, and we have some information on our website regarding DUAs and directing researchers to contact your office. And if we notice in a protocol that it seems like there should be a DUA in place and it hasn't been mentioned, we'll ask about it. So there's some kind of cross compliance checking in that regard.
Great, thank you. I'm going to put the link in the chat for the Office for the Protection of Human Subjects, and that was Adrian. That's her office. Thank you, Adrian.
Sure. Yeah, I'll add another link too that's specific to the FAQs where we talk about DUAs.
Great. Okay, we're coming up on 10 minutes before the hour. So I think we'll summarize and wrap up here. So again, the Berkeley Research Data Portal, if we can repost that, please come back again. We have an ongoing brown bag series, November 9th. Terry Sale is going to talk about sharing your data with other parties. And then we'll have a spring series. And we're beginning now to prep the spring series. So actually, if you have topics that you would like to hear about, questions you have, please let us know. You could certainly reach out to me directly. There's also a concierge on the Berkeley Research Data Portal. So you can also put in something there. It goes to a bunch of us who will see that. So if there are topics you'd like to see, we have a few topics that we've run. Some of those are good perennials. So we'll run some others again that we all need to hear again and again. And then please do let us know if you have additional topics. So thank you, Rick. So that concludes today's brown bag session. Do follow up with any of us if you have further questions, and we hope to see you again at the next brown bag session.